The Burns Chair honors the second dean of CUNY Law School, Haywood Burns, who mentored and inspired a generation of law students, many of whom, much like our students today, were the first in their families and communities to attend law school or even attend college. Haywood's vision for the law school was to recruit and train lawyers dedicated to working for those who have been underserved or not served at all by the legal profession. And indeed, today, 2023 marks the 40th anniversary of the law school. CUNY Law is the nation's #1 public interest law school and consistently ranks among the most diverse law schools in the nation. As the only publicly funded law school in New York City, CUNY Law increases access to incredibly excellent legal training and promotes law in service of human needs. Our students, faculty, and alumni are leading efforts to advance justice for marginalized people across our city, state, nation, and globe. At a time when many of our civil, constitutional, and human rights are in peril, CUNY Law's mission and its graduates are needed more urgently than ever. The Burns Chair allows our institution to remain involved and rooted in the visionary ideals articulated decades ago by Haywood, while deepening our impact on the progressive lawyering work that lies ahead for all of us. It's been over 10 years since we have had a Burns Chair at the law school, so celebrating the reinstatement of the chair this evening marks an important milestone for our community. And so I'd like to take a moment to acknowledge and thank some of the many people who have been instrumental in making this chair and this evening possible. Our partners in Albany have been key to this effort. Many of them who could not be here tonight because of the legislative session currently in progress, but I want to take a moment to thank them nonetheless. Late in 2021, representatives of the law school met with Assembly Member Jeffrey Aubrey, the Assembly's Speaker pro tem, to seek his help in obtaining state funding for the appointments of a Burns Chair at CUNY Law School in 2023. His support was immediate and enthusiastic. He has been a champion of the law school throughout his career, and notably, it was Assemblymember Aubrey who first secured funding to establish the Haywood Burns Chair at CUNY Law School back in 1996. Senator Michael Gianaris played a key role in budget negotiations. His advocacy was critical in ensuring the Burns Chair funding survived the final round of budget negotiations for fiscal year 2023. And those efforts were supported by the CUNY Law alumni who are now well represented in our state legislature. We have Assembly members Catalina Cruz, Harvey Epstein, Daniel O'Donnell, and Rebecca Seawright, and in the Senate, Senator Jamal Bailey. It was this collective effort that led to Governor Hochul signing off on a budget allocation to reinstate the Haywood Burns Chair for this fiscal year. And my thanks to our partners in government for recognizing the enduring importance of Haywood Burns and CUNY Law to the work of upholding civil rights and racial justice. I would also like to extend my thanks to the CUNY School of Law Foundation Board, and particularly its Burns Chair Committee, as well as the many family, friends, and CUNY Law community members who contributed so generously to establish the original W. Haywood Burns Fund back when the chair was first created. And I'd like to offer my deep thanks to my colleague, Professor Nicole Smith-Futrell, for her work and her enthusiasm in bringing the Burns Chair back to CUNY Law, her leadership of the Center for Diversity in the Legal Profession, and her leadership and wisdom in bringing Vince here as this year's Burns Chair. So tonight is about the celebration of the vision and the efforts that brought us here, and it's also inspiration, I think, for what we can all acknowledge as difficult work ahead. We will first be joined by two beloved members of the CUNY Law School community, Jennifer Dorn and Victor Good, to share brief reflections. Jennifer is a midwife, professor, and assistant dean of global initiatives at Columbia University School of Nursing. She's a longtime advocate for justice and educating nurses on the importance of global health equity. She's also the life partner and widow of Haywood Burns. Victor is a professor emeritus at CUNY Law School. Before joining the law school as one of its founding faculty members, he practiced affirmative action and housing law and served as the executive director of the National Conference of Black Lawyers. He is also a longtime friend and colleague of Haywood. After reflections from Jennifer and Victor, we will have a featured conversation between two of the most prominent leaders in racial justice in the legal community. Our Burns Chair, Vince Warren, whose work I have admired for many years and am delighted to count as a colleague for this year, and Janae Nelson, who I have known and counted as a friend for many years and whose work I deeply admire. Janae is the president and director counsel of the NAACP Legal and Educational Defense Fund. Janae determines LDF's strategic vision and oversees the operation of its litigation and policy programs. She is a renowned scholar and advocate, having written about voting rights and election law and litigated numerous civil rights cases. Vince and Janae will discuss their work as lawyers and leaders fighting against current civil rights challenges. We have a wonderful program for you this evening. And to get us started, I want to welcome Jennifer Dorn to come up to the stage. Thank you so much.
I've known rivers, ancient, dusky rivers. My soul has grown deep like the rivers. Eloquent words by Langston Hughes. My late husband was an old soul. During his life, abruptly ended too soon, he brought the wisdom of generations and centuries of freedom fighters. He had the creative ability to bring the values of basic human rights modeled from those who went before him into the present, in building a law school in the service of human needs, of fighting to dismantle the racist structures of law in the United States and rebuild on a foundation of justice and equality. His work encompassed representing those fighting for radical change, breaking down the barriers to transform legal education and the profession itself to represent the face of the majority of this country, creating and leading a national organization for Black lawyers and students, the National Conference of Black Lawyers. And he took his values and experience globally, traveling to many countries, Namibia, Ethiopia, and lastly, South Africa, to help in the writing of new constitutions by and for those newly liberated from colonialism and oppression. This work he did and this life he lived holds many guides for what can be in the future. That to me is the importance of legacy, how Haywood's life holds keys for the way forward. Haywood's family, and some of them are here today with me, and I are deeply excited about the renewed W. Haywood Burns Chair for Civil and Human Rights. I thank Dean Setti and the dedicated team, a really large team, as she mentioned, that has worked tirelessly to give birth to this again. And what an honor that Vince Warren is going to do this. Vince, you bring everything that we could hope to the chair. I'm convinced that with your experience, intellectual strength, passion, dedication, and inspiration, and your deep connection to Haywood, that you will be able to transform the meaning and depth of Haywood's legacy into the present and to the future. And it's wonderful to have my sweet husband there and to have Victor right next to him. So please come up, Victor.
Good afternoon, Dean Setti, Jennifer, Nicole, my other fellow faculty members, staff, and students, and my congratulations to Vince Warren, our new Haywood Burns Chair. It's been almost 27 years since Haywood's transition. That's a full generation. With the passage of time, we can never know for sure what advice Haywood might offer today's students and young lawyers if he were with us today. But I'll take the liberty to speculate a bit because based on the life that Haywood lived, that life continues to speak to some of the challenges that we face today. Haywood began his career as a lawyer with the civil rights movement. He was the general counsel of the the SCLC Poor People's Campaign in 1968. So I think it's safe to say that were he here with us today, he would advise today's young lawyers that being a progressive lawyer means being connected in some way to the many people's movements that are challenging the status quo. While Haywood was general counsel to that organization, in reality, he was called upon to do a bit of everything. And during that spring and summer of Washington, D.C., he did do a bit of everything, but mostly he was part of one of the most critical, important movements of the Civil Rights Campaign. I think if Haywood were here today, he would advise young lawyers that while your specialized skills as lawyers are vitally important, what is equally important is merely your presence. Be part of these movements. See these activists as your colleagues, your comrades, not just as your clients. See their struggles as your struggles as well. One of Haywood's first publications, which he wrote literally right out of college, was a book entitled Voices of the Negro Protest. That was written in 1963. So even that early, Haywood recognized the importance of reclaiming Black history, even before there were Black Studies programs to carry out that task. So I'm sure Haywood would see this current conflict going on around us today about Black Studies programs as a battle that young lawyers need to roll up their sleeves and be a part of. He would also have seen that this is not simply a debate about the intellectual content of these courses, nor even an honest disagreement about when or where critical race theory should be taught. This conflict is not about the facts. This is an ideological struggle by some who, by seeking to control the access to our past, seek to control our future. Haywood would remind us of the centrality of defending the First Amendment, a section of our Constitution that began to receive its full breadth and meaning in the political struggles around the Espionage Act in 1917, the anti-communist purges of the McCarthy era, and the struggles of the NAACP during the Civil Rights Movement. And finally, Haywood would tell today's students to become internationalists. The struggle for justice and peace in the world are inextricably linked. And when Dr. King advised that an injustice anywhere is an injustice everywhere, he was not speaking only about the struggles of the Deep South. And in today's political arena, as our nation marches once again toward war, the presence of progressive lawyers is essential to help push back the hands of the doomsday clock. This clock, to those of you who may not be familiar, is how we measure how close we are to nuclear annihilation, and its hands are only a few minutes before midnight. So there is much work to be done. But in plunging into the political turmoil of the day, Haywood would remind us that there will be time for friendship, time for laughter, time for moments of profound self-realization, and yes, even some time for some fun. So as I think about my friend Haywood this afternoon, I can hear him leaning over, as he was in that picture, and pulling me close to him and saying in my ear, "Let's get together after this meeting is over." That too was part of Haywood's legacy. Hard work, dedication, commitment, but at the same time, the ability to connect and to have a little fun in the process. Thank you. And now I'm happy to turn the next section of our program over to Janae Nelson.
Hello, everyone. Okay, I'm so sorry. Maybe they didn't do this in the Burns chair before, but I'm a call and response guy. Hello, everybody. This is what I'm talking about. Thank you all so much for coming, and thank you, Victor, for the wonderful introduction. Thank you, Jennifer, for holding and nurturing the legacy in the beautiful way that you've had all these years. Thank you, Dean Sethi, for all of the support for this program. Thank you, Professor Smith, and team for the incredible support of me in this program. I'm Vince Warren, and there are a few things you need to know about me. One is I like to keep it real. Two, I'm radical as hell. And three, I could very much get emotional during this conversation right now. So I very much want to say that the first time I met Haywood Burns was in this law school in 1990-something. And I was a law student, I was a pre-law student. I actually hadn't even been to law school yet. And I had worked, in ways that young lawyers and young pre-lawyers can with luminaries. I'd worked with Haywood in the context of the National Conference of Black Lawyers, the National Lawyers Guild, and he was just a superstar to me. I couldn't believe that they made a human being like that. And the thing that you don't know, and everybody that's met that knew Haywood, and it's not necessarily reflected in this picture, is he had the most extraordinary twinkle in his eye. With this playful, we gonna do this thing, twinkle in his eye, and you really felt like anything was possible. And it is quite something for me to be here on this stage, in this chair, in that chair, being, probably a little older than Haywood was when he died, when I first met him as a little young guy that didn't know nothing. But I'm thrilled to be here, and I'm thrilled to be in the CUNY community, and I'm super thrilled to introduce you to my friend, and someone that I've been pleased to work with over the many years, Janae Nelson of the NAACP Legal Defense and Educational Fund. So we're going to talk today about what the work looks like now, honestly, what it's like for people in, I was going to say our generation, but maybe we're in different generations. I appreciate you. What it's like to sort of take over the mantle of leadership, both I think in extraordinary organizations like the Center for Constitutional Rights and the NAACP Legal Defense and Educational Fund, and also what it means to be sort of on this stage as sort of carrying on that legacy. So, I wanted to start off by asking you a question. I've known you for a while, and you have been, that's not gonna be like that. She's like, where's he going with this?
Exactly.
But it's extraordinary that you are running this organization that you were a staff attorney at. What has that been like for you? And how long have you been doing it?
Wow. So first, I will answer that question, but I have to congratulate you on assuming this chair. It is such a wonderful honor for a career that has been so spectacular and so impactful. So I don't think you could have picked a better person to fill this chair. And I also want to acknowledge the family and thank you for being here, because it's so important that we remember the legacy of those who came before us. I was telling Vince when I just got here that Haywood, if I can call him that, passed the year that I completed law school. And I heard about him. He was legendary. He worked at the NAACP Legal Defense Fund. He clerked for Constance Baker Motley. He is part of the family of the Legal Defense Fund. And so it is such an honor to be here in conversation with you and to be back at CUNY Law School. I was here several years ago, but to really honor his legacy, because it's one that I admire so much, especially his connection of civil rights and human rights, and recognizing that there's very little, if any, daylight between them. And his ability to see the world struggle, the global struggle for racial justice so clearly and so keenly before we had the internet, before we had all these connections that made it so obvious. He saw that and he made those connections very early on. So It's wonderful to be here. And it's wonderful to helm the Legal Defense Fund. We are an 83-year-old organization next month. And to take up the mantle that has been passed down, I am the eighth president and director counsel. So this is not an organization that has passed through many hands. It is one that has been very carefully stewarded. It's one that has been held and protected, and that has, I think, made incredibly important interventions in this democracy and has helped to birth this democracy in so many ways. So it's a big responsibility. I started at the Legal Defense Fund as a baby lawyer, coming off of a fellowship where I worked at a law firm for 2 years and then came to work at the Legal Defense Fund and thought I would be there perhaps for 2 lucky years, and wound up spending several years there and went into the academy and was able to teach at St. John's University School of Law, and also began as an associate dean and got into the administration, like Dean Setti, who I'm just so proud of. You've done such an amazing job as an academic and now as a leader of law institutions. So thank you for that work. But I knew her husband as a Fried Frank associate. And to see that trajectory, to see that now all of us are doing these things. And I never dreamed that I would be leading the Legal Defense Fund. I thought I would just stay there as a staff attorney and live out my days fighting the good fight in that way. But I'm happy to be doing it in this way.
That's wonderful. And we're all super proud of you. Super proud of you, and very excited.
Thank you. Thank you.
You know, and also excited about the work that LDF and CCR have been doing together for the last couple of years. It's actually a strange thing in this field. You have organizations that can be aligned in so many ways, but they sometimes just don't work on cases together, which we have been. The stop and frisk case, our organizations have been working on. The gang database case, our organizations have been working on together. And just, you know, in terms of so I'm gonna tell a little story. In terms of becoming the head of the organization, I've been the head of CCR, I think it's like 16 years or something. I thought I was gonna be there for 15 minutes. But I actually never wanted to run an organization at all. And there's one person that I'm gonna blame for this publicly, which is Professor Franklin Siegel, who I was an Ella Baker intern, a summer internship. Hit me up if you want to learn about Ella Baker internships. And after I was an intern there, Professor Siegel said to me, "You really should think about coming to CCR." I'm like, yeah, I don't know. And he's like, "You should really think about being on the board," because they wanted younger people on the board, and I was younger back then. I'm like, that I can do. That was like 20-something years ago, and here I am. I'm like the executive director, so I blame you, Professor Siegel. But part of, I'm telling that story, but you know, the CCR family really invested in me as a person, as a sort of a promising black kid that wanted to change the world through lawyering. And it's a lot of what I see here at CUNY Law School about that investment that I think we both very much felt from our institutions, from our colleagues, from people that we respected, that they trusted us to kind of not necessarily lead, but they trusted us to sort of make some good calls and some judgment calls and do our best. And that's been extraordinary. What have you seen as some of the changes in LDF recently? And so has it shifted its focus significantly in the last 83 years, or?
It has evolved, of course, as any good institution does, right? You don't stay stuck in the sepia tones of 1940. You have to be nimble, and you have to be flexible and responsive to the demands of the day. But I will say that we have held our core, we have held our culture, and that has been, in my view, the most important ingredients to our success as an institution, to our longevity. We were founded with a vision of imagination, of just great clarity about what was possible, even though there was nothing in the present of Thurgood Marshall or Charles Hamilton Houston or those who helped to birth this institution. There was nothing to indicate that what they were dreaming of was actually tangible and feasible. In fact, they had every indication that it couldn't be. They saw all sorts of obstacles in their way. But they knew that one, the order of things was wrong, right? That this was just not a just way of a society organizing itself and operating. But also, they had enough faith in their own intellect and their own ability to transform an entire society that had been constructed against their own humanity, that they could see a vision for that. And they could be the architects of their own destiny and future and those of the communities that they represented, which, is in my mind, the most transformative leadership you can possibly have is such visionary leadership. And so the Legal Defense Fund, I'd like to say, has continued that over time. The obstacles are in different shapes and different clothing and cloaks, but many of them are very much the same. And sadly, and I heard Victor say this at the outset, some of these things are sort of coming back in ways that none of us would have imagined that we would be fighting today. The book bans, the attacks on truth and speech, the outright bigotry, the open hostility and racism, the white supremacy that we knew was always there but has now been unleashed and encouraged and nurtured and nourished by people who hold the highest offices in this country. That is something that you have to constantly be flexible and nimble in order to address these evolving threats. And so, yes, to give you a long answer, we have absolutely changed and shifted over time because you have to. That is the work of racial justice, is to dip and dive and dodge and create an offense whenever possible.
And the offense is really, really hard to do when there's all this stuff coming at you. But let's talk about this a little bit more, because I think the models of LDF, and I agree with you, that being able to hold on to that culture, which, in so many ways, I think represents the best, amongst the intellectual best of Black thinking, the idea that there's a there that people will tell you, first of all, I don't even know why you think you can be a lawyer. Second of all, that you're a lawyer, I don't even know why you think you can win this case. But having a really clear path is extraordinary. And that model works, and I think it's also important to remember that there are other models as well. So the CCR model is almost the exact opposite of that, right? So we've been around since 1966. I'm terrible at math. Somebody can, put it on Twitter how many years that is. But our model has been, as you know, social movement lawyering, and so our work evolves almost on a daily basis, depending on what the social movements are calling for. And it's important, I think, as being one of two Black leaders of CCR, Ron Daniels was before me, that in order to kind of hold and center Blackness within our work, that we have to be able to do both of those things at CCR. So we have to be able to move out in the world. So we've been partnering with groups like Movement for Black Lives, but we also have to be able to really hold on to and hone our litigation, our racial justice litigation, both domestically and internationally. So let's just use this other lens. So Ferguson happened in 2015, and there's the Ferguson uprising and there's the Baltimore uprising, and those uprisings by folks really created a question mark about how legal organizations should respond to that. And everybody, I think, responded in the ways that I think made a lot of sense. It just has that kind of the idea that uprisings can happen and can really shape the situation. How has that influenced the way that LDF thinks?
Absolutely. So I'm glad you pointed out that sort of model, right? There's different lawyering models, which I think is very important for the students in the room to recognize if you're thinking about different institutions that you might want to associate with. And all of them are necessary. I want to be really clear, all of them are necessary. So LDF is an organization that is rooted in impact litigation, but we do so much more. We have a huge policy arm, we have a huge organizing department, and we actually, and now that's a relatively recent vintage, the size of our organizing department, but we had an organizer on staff back in the 70s, a full-time paid organizer, right, which was kind of unheard of at the time, because usually that was volunteer work. That was what people did on the side. We saw the value of that early on. We knew that our litigation wins would not hold, that they would not be durable if we did not have communities that were organized enough to hold the people, entities accountable, right? And who did not have some sort of framework to be able to tap into if there were further injustices. So organizing was always something that was part of our strategy, but it's now become so much more. And what I think is really, really interesting about the different types of models of lawyering is that you need to have institutions that have a relationship with the court system. It is too important and too, in many ways intrusive an institution not to have an organization that has presence and has credibility within that system. You also need organizations that have credibility with grassroots organizations, with individuals on the ground. We try to do both, but it's always helpful to have partners who are very reactive and responsive to those needs on a regular basis, which is what CCR does, and really echoes and amplifies those voices quite regularly. And so that's why I think our partnership on these cases has worked so well. We worked on the stop and frisk cases together here in New York, and you mentioned the gang databases. And as we see, that work goes on. We're monitoring consent decrees. We're trying to hold the city to account still, even though that win was many years ago. And you mentioned Ferguson. Ferguson, we're coming up on the decade, decennial anniversary of the Ferguson uprising when Mike Brown was killed in 2014. But that was not the first time that Black America or America generally had been outraged by police violence. We know Rodney King occurred. We know that Trayvon Martin happened, right? We know that there have been so many. I mean, I could rattle off a billion different names, sadly. But it's in those moments where an institution like ours has to be nimble. So this goes back to us being flexible. So we have our impact litigation, we have our legislative advocacy, and it's plotting, it's thoughtful, it's intentional and strategic. But we also have to be ready to take advantage of any opportunity that presents itself. And an uprising, a tragedy like that of Tyre Nichols opens the door for us to say, look at this, let's leverage the emotion, the outrage into something that is transformative and allows us to make more progress in this moment than we could if we were doing this just on a daily sort of plotting basis. And so in reaction to the Tyre Nichols brutal slaying, we issued a framework for public safety that is in many ways echoes of what we've been saying all this time, but it's now getting greater receptivity because people can see firsthand the ludicrousness of having a unit that is designed to terrorize communities as a crime prevention measure. That when we really crack it open, that it makes no sense. That's not a good investment of taxpayer dollars. It's not making us any safer. It's terrorizing communities. And in its worst form, it is actually killing innocent people. So you've got to have that versatility and that dexterity to do this work and to take advantage of every possible opportunity, because certainly those who are arrayed against racial justice and progress are doing that quite well, as we see.
All the time, every day.
All the time.
Yeah, I really appreciate that because I think, our intervention in Ferguson was surprising to me, actually. Because as you said, things were happening, very, very quickly, and we were getting all of this information about what was going on. And that CCR is very nimble and it does move to the ground, but there has always been well, maybe I shouldn't say always, but there's been a sense like if there's not a big case to file, it may not be worth the effort. And what the folks, my team was saying to me was that the organizers in Ferguson actually don't need a big case because there are other groups that are there. The ACLU's there, LDF's there. They've got a lot of those things covered. What the organizers actually need was how do you keep people in the protests, on the front of the protest line? Because what was happening is I think there's something like 83 maybe 91 municipalities within St. Louis County. And what was happening is that Ferguson was going on, people were protesting, they were getting arrested, and they would be then sent to any one of those 91 municipalities. They were in jails all over the place. And so the organizers were like, listen, as soon as the people stop protesting, then the cameras are going to go home, and then it's going to be business as usual, like it has been like for the last 100 years outside of St. Louis. So we got to keep the people on the line. So my team and the National Lawyers Guild created the Ferguson Legal Support Network, and what we were doing was we were recruiting people from St. Louis who are criminal defense lawyers to be able to create a network to represent people so that they could get out of jail and get back on the front line. And when you look at how, just as you were saying, the different strategies come together, when they work together, they can be much more powerful than what any individual organization could do. I wanted to ask you about, Victor was mentioning critical race theory. And so and I was on a call, I remember you convened a call, it was during COVID years, so it could have been any time in the last 30 years, I don't know. But you convened this call in which people were really engaging around the strategy. My question is, well, maybe it's not a question, it's an observation. It seems very meta to me that I went to law school just as critical race theory was catching ground. And not all of the professors were into that kind of stuff in my law school, so I kind of learned it on the back end. And it actually has totally shaped the way that we think about structure and white supremacy and what's necessary. So now law students and some of the younger attorneys are coming in with critical race theory as the lifeblood of what they expect the organization to do. And then here comes the right wing and saying, guess what, we're gonna ban it.
Yes.
What do we do with that?
So, God, that's so much. I mean, what a great observation. Yeah, it's exhausting to think about what has happened, what's transpired over the past couple of years around critical race theory and around truth generally, because critical race theory is now a stand-in for anything progressive. It's now expanded to envelop anything that is a threat to the status quo and that uplifts the stories and the lived experiences of marginalized communities, whether they be Black people, other people of color, LGBTQIA, people with disabilities. I mean, it actually has now just become the biggest othering that I've seen in my lifetime, at least. So you were on that call, it was 2019, and it was because I happened to have read, we knew it was coming because we got sort of an advance notice, but the prior president issued an executive order 13950, which is like etched in, I should probably get it tattooed on me because I was so incensed when I read it. And it was the first time that I saw in such stark relief our story, our history being turned against us in such a dangerously artful way, if I'm to be honest. It was, it invoked Martin Luther King Jr., it invoked slavery, Abraham Lincoln, all the principles and profits of equality and democracy, to say that it would be antithetical to our colorblind form of government to allow any federally funded agency to talk about diversity, equity, and inclusion, to include in their trainings or include in even their educational materials anything that might cause offense based on one's race or origin. They did not want to cause anguish or fear or concern or all of these sort of fragility terms that were in an executive order and that were stripping funding from the military, from all federally funded agencies and federally funded grantees. And so that just, I saw that and the blood started to boil. I spoke immediately to Kim Crenshaw, who is one of the originators of critical race theory. And this is before she had become such a focal target. And unfortunately, it has really just metastasized over time. But she and I spoke, and we said, we've got to get all our civil rights colleagues on the phone and figure out a strategy. This is the opening salvo of what is going to be a torrential assault. I mean, so we saw it. We knew it was going to be what it has become. And so that was one of the opening conversations that we had about what to do. LDF went on to file a lawsuit, and Lambda Legal also did as well in Northern California. And ultimately, as you know, we got a new president and the executive order was rescinded. And thankfully, it was replaced with one that was meant to be and is meant to be an antidote, an executive order to advance equity. And I want to lift that up because it is important that we don't just beat back these assaults. It's important that we replace them with something that takes us much further than where we are. Because when these assaults are successful and when they take root, they also reveal a vulnerability. They tell us that what we had was not sufficient. In order for something like that to even gain enough traction in our government and in our society, it tells us that where we are is not safe and secure enough. And so there's more that we need to do. And so that is what LDF is engaged in right now. We have a very robust pro-truth campaign that is not only pushing back against these laws, but also trying to seed a new vision of what it means to live in a multiracial, inclusive democracy, to have an education that's culturally responsive, to make sure that truth is at the center, no matter how difficult it is to grapple with, because that is the only way in which we are going to be able to do the work that we do. That's our currency. Our currency is to bring truth to courts, to bring truth to legislators, to bring truth to all positions of power, and to lift up the voices of those who can't be in the room. And we do that by truth telling. So when those stories are denied, when they are banned, when the entire next generation of residents of this country don't have access to the truth and to history, we are in a very, very dangerous place. So that is one of my biggest concerns in the moment in terms of the threats facing us, not just in the realm of racial justice, but in the realm of our democracy at large.
You were talking about how civil rights and human rights, there's no daylight between the two, which I totally agree with. And I just wanted just to share a little story about the going on the offensive, because you were mentioning before that we have all of these strategies because they just throw crazy stuff at us, and we have to figure out how to put out fires and how to seed the future and that kind of stuff. But part of, I think, what has resulted from the current generation of thinkers, organizers primarily, has been around understanding the permanence of our condition relative to things like incarceration and being in cages, relative to things like our own history. There is a permanence to, if you look back long enough, that there used to be a time when not only when white folks did stuff to black folks, it was heralded, it was in the newspapers, and then there was a time in which it got shut down and it switched to state-based terrorism and all of that kind of stuff of how people are treated, and now they're pretending like none of that happened. Like we're trying to tell, and they're like, that I'm sure that didn't happen, and even if it did, I would rather that my kids not be traumatized by learning how we killed you. So that's kind of where we are now, but I've had a really interesting set of work at CCR around the question of reparations. And it didn't actually come up as a reparations case. It's an interesting case. I talked about it in Professor Davis's and Professor Suhu's class on gender and human rights. And the story is about black folks that live in what's known as Cancer Alley, Louisiana, right? It's in between Baton Rouge and New Orleans. And if you actually if you look at a map of slavery in 1860s, and then you look at a census map, it is still very highly concentrated with black folks. The difference now is that the black folks there are no longer enslaved, but they are encapsulated by toxic companies. They call it Cancer Alley because it's the highest incidence of cancer any place in the country. So we have been representing a group called the Descendants Project and a number of different organizations trying to push back on the building of new chemical companies. And in doing that, you would think that that's a environmental litigation. We're not really environmental lawyers, right? We're human rights and civil rights lawyers. We'll learn what we need to learn. But we did, in our litigation, learn that the former parish, head of the parish, basically took bribes to get the companies to be able to come in, which built all of this stuff, which are killing all of these people. And so the litigation that we have now is about a 1990s bribery case, and we're having to show that the company that says they want to build on this land actually was able to say that they were going to do that because of this fraudulent deal way back when. So history becomes very important. Well, we had an opportunity to take that case and talk about it in Geneva at the United Nations, at the Covenant on the Elimination of All Forms of Racial Discrimination, where US groups from civil society will go and speak to the UN committee that is actually asking the question, what has the United States done for racial justice? And if you've ever been to these things before, you imagine what this is like. You know, civil society shows up and they're like, yeah, y'all ain't done nothing. Look at all the stuff. We've got all the things. And the government shows up and they're like, we've done a whole range of things. We're more diverse. We're more, you know, that kind of stuff. But when we get there, the women who we brought our clients with us, and they essentially made the case not just to be relieved of the burdens of having to breathe in toxic chemicals, but they made the case that this was land that our great-grandmothers bought. Like when emancipation happened, some of our family members had the opportunity to buy land, which they did in the 1870s, and it's been part of our land now. And the problem is that black folks bought the land around the former plantations. The plantation owners sold their land, they cashed out. And so now you have a situation where you have black ownership for the first time in 400 years that now is surrounded by an enormous cash out where the descendants of the slave owners sold to corporations. So in the context of the commission, the CERD committee, which gave reflections, did two things that they'd never done before. One is they heard the testimony of our clients, and they called for the United States to essentially investigate and end the toxic chemicals in that particular region, called it Cancer Alley. And the other thing that they did was, for the first time, the UN committee called on the United States to take seriously the need for reparations. Mm-hmm. And it was such a wonderful experience, because we have debates about reparations and what are you gonna be able to sue? What is it gonna look like? And our partners, the people that have the most experience and have the clearest sense of what justice looks like, were able to go to Geneva and say, come on. We bought this land, and now they're poisoning us with it. And that's the power of both the civil rights framework and the international, the human rights framework, is that it brings both of those things together. So I was telling that story because we're at a point where, although the call for reparations is not new, people have been calling for reparations long before we were born.
It's 40 acres now?
Exactly. But we're in a situation where we're struggling to figure out what's the legal hook there. Is there a legal hook here? How might we do it? Are these conversations that are happening at LDF? Are lawyers coming in with a fire in their belly about reparations, or are people saying maybe it's not a legal strategy? Like, what's going on?
Yeah, wow. So one, I want to commend you for that work. That's just it's difficult work. It's really, really difficult work, and it's great when you have another angle. So the idea of a bribery charge or some contractual misleading of the people who took the land. I mean, whenever you can ground it in principles that power structures respect, which is ownership, which is proprietorship, you've got a leg up. When you're thinking about justice, equality, due process, other principles and standards that are less respected, it's a more difficult road. So just, nota bene, this is just a way to kind of like get around some of that. So I hope that that serves you well.
And by the way, it was CUNY law grad Pam Spees came up with that strategy. So
there you go. Look at that. So yes, those conversations are happening. I would say, our organizers have been very, very vocal and really good about ensuring that we look at everything from a reparations lens. And frankly, I feel that so much of our work is about reparations, even though we're not naming it as reparations, right? When we ask for there to be a consent decree to govern an injustice and ensure that those harms are reversed, or that there's some compensation, or that there are new structures put in place to ensure that it doesn't happen again, and that those who were harmed are made whole. That's a very discrete form of reparations, but it is that nonetheless. But what you're talking about is, reparations writ large, thinking about how does this society pay its debt to the many peoples that it subjugated and disenfranchised and stole from and pillaged and raped and murdered and tortured. This country is not ready to confront that, but that does not mean that we should be stepping back from that. I do think that too many organizations feel that reparations is such a big and enormous challenge that it is like boiling the ocean. And we cannot let the perfect be the enemy of the good. There are so many concerns about, well, what about, how long of a generational, line are we going to compensate people for? And what about people who were not born here, but who nonetheless suffer discrimination because they're Black and because of a legacy of enslavement? There are a lot of thorny intellectual, philosophical questions that could take, the rest of our lifetime to figure out. But that can't impede us at least making the claim that reparations is an entirely justifiable and worthy cause to take up. And it begins with doing the study, right? So the UN suggesting that there be an investigation and that we take up the issue of reparations seriously. We have not even been able to pass a bill to commence a study about whether there ought to be reparations.
how many years have we been trying to get that bill passed?
Exactly. It was HB 40 before. I think it's going to come up again, hopefully in the 118th Congress. LDF has submitted testimony. It is gaining traction. But this is one of these moments where, when you see the effort to try to bury this history, and you recognize that if that happens, any potential for reparations will be gone. Right? If you don't have the factual and historical basis on which to make that claim, then any possibility of leveling the playing field, especially for future generations, will be lost. And so this is a moment not only to demand truth and not only to demand access to information and not only to ensure that the lived experiences of marginalized people in this country are centered, but to say that these very bold, radical ideas are mainstreamed, that these should not be at the fringe any longer, that we should have honest conversations and debate about how we go about repairing this society that no one can deny, if you're being honest and objective, was built on the backs and lives of so many peoples who have never been given any recompense at all. And I don't mean just financially, I mean even in terms of opportunity. And this effort to suggest that our society is now colorblind and it is somehow racist or discriminatory to take account of race when race has been the driver of every system in this country is absolutely ludicrous. And it is the type of wordplay and sort of house of mirrors and smoke and mirrors that is intended to make those of us who stand on principles of equality, feel that we should back up a minute, that maybe we are pushing something that is contrary to our belief system. But we have to recognize, and reparations gives us that lens, that when you think about a harm having been committed and the need to make people whole, the need to make the society whole, it doesn't feel like something that's unfair and unjust just because you weren't necessarily alive at a particular time, especially when the effects and the impacts of those past injustices are so real and tangible and palpable today. So I think that centering conversations around reparations is the type of it's the type of bonus we get when people overreach in the way that they are doing right now. We get to take something that was marginalized, that was identified as a fringe theory, and say, actually, it deserves attention, and this is exactly why. Because without that type of honest, rigorous, and difficult discussion, you are trying to take away even the most basic tenets of equality.
Absolutely, and I think, you know, this goes back to Haywood Burns and how he thought about my impression of how he thought about law and politics, right? Which is that some lawyers make the mistake of thinking that law alone is be able to move things. Some lawyers make the mistake of thinking that their political rhetoric is going to just move things, and it's really an interplay between the two. And you know, like if you think about the challenge that we have in terms of how we litigate, that sometimes precedent is the problem, and that's like when black people need to be free. We really should not have to be looking back in the dusty books to find another case that said black people need to be free, because it's not there, right? So precedent is a problem. And then sometimes when precedent isn't a problem, then politics are a problem. Like, how are you going to get a judge to believe this? How are you going to get Congress to be able to move this? We're in a moment where both precedent and politics are the problem. And I think that taking a page from Haywood's book and thinking about the role of the lawyer engaging the political moments of the day, I think becomes increasingly important. And so, I think reparations is one of those things, because, you know, when you were talking about, and I know these conversations, man, about all the people that are like, here are the 39,000 reasons why it doesn't make sense to think about reparations. Well, what happens if they moved on this date? And what happened if their parents came on a plane and as opposed to a boat, they came and changed? You know, and it's weird because people lose the political vision and they start thinking like mass tort lawyers. I mean, this is not a mass tort, like, you know, this is not one of those things where you have to send out this thing, and if you were brought to this country and changed between this year and this year, you could be entitled to it. That's not what we're talking about, right? So, the way I'm beginning to think, Janae, the way that you laid out the way that LDF, or the way that you're thinking about reparations, which is that when you look at the Movement for Black Lives manual, they have this fantastic teaching manual on reparations. The first elements of reparations are amongst the following things. One is an acknowledgement that harm was done. 2 was a cessation of the harm, and 3 was the creation of a mechanism that will ensure that the harm will not continue. And those 3 things can be elements to even the most basic core civil rights litigation that we do. And I think our challenge as lawyers that think in terms of human rights and civil rights and really thinking about the future of this is going to be how do we shed the idea that our liberation is not practical in legal terms, and how do we begin to think about the pieces that we've already created, that have been created for us, that we've been benefiting from, and move that forward. And I was in a conversation with Sima Lupert, who is from Namibia, and she has been working with the European Center for Constitutional and Human Rights. Wolfgang Kallig, who was with the Sorensen Center here last year, has been leading that litigation. And she was saying to me that the biggest challenge around the question of accountability is everybody knows facts are. Everybody now acknowledges what happens. People are actually trying to get the bones of their ancestors back from these vaults in Germany. Mm-hmm. So everybody knows what the deal is. It's the politics that get in the way. And that there was a lawsuit that was filed in the United States and they lost. But she said it was a tremendous victory because the lawsuit that was filed in support of our case was the only time that we received an acknowledgement in court of what has happened to us. And I think those are the things that we can continue to build on in the civil rights and the human rights community.
No, I absolutely agree. It's interesting. I want to follow up on 2 points you made. One was about precedent, and this other is about the cessation of harm. So with respect to precedent, I mean, I agree with you that precedent can be a significant problem. Although we know of precedent that we've recently lost, that is, that was quite helpful, right? In that there's, if we look back at the arc of precedent in this country, it's recent precedent that is being abandoned and manipulated and disrespected by the court in ways that are deeply harmful. And so I just want to be clear, I don't think it's all precedent, but what it does reveal is something I said earlier, and that is that, that precedent didn't go far enough, right? It didn't do enough to lock in these principles in such a way that they were not vulnerable to attack or reversal. Now, some of this, I think, is really part of the court just being far more activist than we've seen in recent past. So that's one concern. But there's an interesting way of thinking about the arc of how precedent has evolved over time. And it has been a rights-expanding, rights-affirming precedent in most instances when it comes to civil rights over the past few decades until it took a turn in the 90s and has slowly crept back. So we had a little sweet spot. And then it dissipated. But the other thing about the idea of the cessation of harm, which I agree in principle that obviously part of reparative justice is to make sure that you stop engaging in the harm that instigated the process in the first place. But I also think that we have this desire in this country to solve the problem of race. Right, that there's a way that even if we could throw money at it, it would go away, or we could, say this is it. We're gonna engage in a reparations process, and this is now going to, solve this bitter part of our history that has been our albatross for our entire existence. And I don't think there is any such thing. We are, in my view, going to be actively engaged in beating back the cancer of race for the entire existence of this country. It is in our roots. It is at the soil and at the foundation of this country. And the sooner we accept that responsibility and accept that that is the duty and the work in exchange for living in this, unprecedented, diverse, multiracial, multi-ethnic, vibrant mosaic of a democracy, then we will be so much better off if we understand that that is the price you must pay in order to have this, right? You don't have this type of constellation of people and of differences, of just the ideological diversity and variety that we enjoy in the marketplace of ideas that we celebrate in this country without doing the work of recognizing that it can be compromised by our history at any moment. And that's just part of what we need to accept as part of being American or American residents. That is the work of this country, and it doesn't go away. And that has just, I think, some people don't like to hear that because we like to think that we can one day conquer and overcome this thing. But I do think we can help it dissipate. We can help it fade to the background. But whenever we turn our backs on it, if we think it's not going to creep up again, if we don't think that there are still going to be elements in this society that will unearth it and give it life again, we have not learned anything from our history. And so that's something that I just want to make sure that those of us who believe in justice and believe in long-term solutions to racism and so many other pathologies, that we recognize this is a long game, a very long, if not eternal game. But it's okay, because I think the fruit on the other side of it is so worth it.
I really appreciate those words. I'm gonna close this out, and I want to just add a little something to that, which is that when I started out, when I decided that I was going to go to law school, I don't think I ever had this conversation with myself, but I was pretty convinced that I was going to solve everything probably about this point in my career. And I began to realize, and I still do realize, and particularly I think in light of being selected for this incredible chair, about the wisdom of the struggle. So my people talk about the struggle as eternal. And my people talk about, I mean my people politically, they talk about the idea that each one of us has a kind of a clear role to play in doing that. There is tension though, because I think younger generations can teach us about how to not accept certain formations and societal formations, like gender, for example. Like there's a classic example that people just refuse to accept it. In society, we're having a big debate about it, and I do suspect and I do expect that the way that society is structured is going to fundamentally be changed over the next 15 years on the question of gender alone. And I do think that part of the real opportunity and excitement about being in these roles that we're in, being on this stage in this community, is being able to interrogate the question about, yes, we're going to be in the struggle forever, but can we recalibrate what we're willing to accept during the time that we're in the struggle? And that's what's really kind of exciting about being in this space and being here with you, my friend.
Oh, thank you, thank you. Well, I'll just say, because I have to give my philosophy on struggle as well, the eternal struggle. It means you cannot have struggle without evolution. I mean, you're not just struggling in place, right? I mean, you're struggling to evolve and to progress. And that is, I mean, that is what this is for, right? Is to never be satisfied, to never just live in a constant state of fighting to no end. It's to always be advancing and to be evolving society towards its highest ideals and towards, as you point out, with respect to gender, with respect to so many constructs that perpetuate injustice and inequality, to constantly be rethinking them. And even those of us within this progressive society or progressive group of advocates, that we also have to question ourselves and make sure that we are doing that work. So I'm here for the struggle, and I'm so glad to have you in it.
Thank you, Sue. Thank you. Thanks, everybody.
It was great.